Hello there, Legal Systems in America, taught by Kelly Rogers. I'm Kyle Harwood, and with my group members Sam Tyler, Brianna Hogum, and Kayla Noble, we, for our Comparative Law Project, compared United States and Germany.
German law has developed over centuries of several different sources. Until the medieval times, the Germans used the court system. Then they started using Latin law codes, which were influenced by Roman law, canon law, and tribal customs, and people were tried based on their race, such as Romans, Franks, Bavarians, etc. Before the laws were written, German laws were kept by memory of people who held office in the judiciaries. Roman law was heavily influenced by Germans during the Renaissance era, or influenced the Germans, my bad. After the French Revolution in the 1830s, the Germans incorporated some of their laws into their own. In 1871, the German legal system underwent major changes within all fields of law, from criminal to procedural, and after 20 years of writing, the Book of Civil Law was created.
During World War II, the laws in Germany were called the Nuremberg Laws. They were laws for the protection of German blood and German honor. They were put in place by Hitler. They banned marriage between Jewish people and non-Jewish people, and they also criminalized sexual relationships between the two. This was known as race defilement in the law. It also prohibited Jews from employing any German woman under the age of 45 because they believed it would cause Jewish men to commit race defilement. And because of this law, thousands of people were convicted of race defilement and were sent to concentration camps. The Reich citizenship laws were also a part of the Nuremberg Laws, and these stated that only people of German and kindred bloods were actual citizens of Germany. Despite the Nazi claims that there was no scientific way to define Jewish as a race, those who had 3 or more grandparents were born into the Jewish religion were Jews by law, and Jews in Germany were subjects of the state. Mixed race were those who only had 1 or 2 grandparents that were born into the Jewish religion, and they got the same privilege as Germans. The Nuremberg Laws laid the foundation of legally separating Germans and Jews during the World War II. And in 1941, the Allies of Germany, or those who were dependent on them, had all created their own form of Nuremberg Laws.
So following the Second World War, ushering in the Cold War era, Germany was separated into East and West Germany, with the West following the capitalist and democracy ideology, and the East following the communistic ideology and opposite. East Germany used laws that naturally had communist roots with the socialist ideology, and vice versa with West Germany, based on the democracy and capitalist society that was somewhat originated there. When they merged together, West Germany's law dominated.
The U.S. judicial system originally came from English common law. Common law has been the system that has been in place in England since 1189, when the Normans first invaded England. Despite this background and all these influence, America has begun to forge their own system. During the 19th century, they adopted their own rulings, principles, and precedents. And during the same period, between 1810 and 1910, the number of legal reports filed went from 18 to 8,000.
The Articles of Confederation, which was ratified in 1781, was a confederation of loosely organized independent states. The national government under the Articles of Confederation consisted of a single legislative body called the Congress of the United States, and there was no legislative or judicial branch under the Articles. The Constitutional Convention in 1787 followed by the development of the United States Constitution itself, which then was later ratified in 1788, and the first Congress in 1789.
Article 3 of the Constitution is the main article to deal with the judicial branch in the U.S. system. It requires the establishment of a Supreme Court, and it permits Congress to create other federal courts, and it places limitations on their jurisdiction. In Article 3, it's stated that federal judges are appointed by the President with the consent of the Senate, and they serve until they resign or are impeached and convicted, retire, or die. Article 3 was followed by the Judiciary Act of 1789, which created the first lower federal courts. And some other important dates to keep in mind are 1869, when the Circuit Judges Act made it so that the amount of judges on the Supreme Court was 9, and in 1982, when the U.S. Court of Appeals was created to reduce pressure on the Supreme Court.
So in comparison to the internment camps that were in Germany during World War II, America had their own. In February of 1942, President Roosevelt issued an executive order saying that all Japanese people, citizens or aliens alike, were to be relocated into internment camps within the confines of the United States. The claim was that it was to protect Japanese people from those who wanted to retaliate because of Pearl Harbor, and possibly as well as to prevent any thoughts of espionage from the Japanese. 117,000 people were affected by this order, and about two-thirds of those 117,000 were people that were naturalized citizens within the United States of America. After the war had ended, only 3 people questioned if they were constitutional to have relocated. I'm sorry, my bad, I misspoke. After the war ended, only about 3 people questioned if there were any constitutional rights that had been violated due to the relocation of the Japanese people during this time. These internment camps were acted like ghettos and had strict curfews, food rations, and were overall not a fun place to be living.
Because the United States judicial system is both part of the common law system and also an adversarial system, it's important to talk about the landmark cases that pertain to it. The first was in 1803. It was Marbury versus Madison. It was the first time, other than in the Federalist Papers, that the exercise of judicial review was investigated. In this case, Marbury decided that judicial review was constitutional, and under this, the executive and the legislative actions are subject to review by the judiciary.
The second of the one big landmark cases would be the 1963 decision in Gideon v. Wainwright. This guaranteed the right to counsel. A man in Florida had been arrested on felony charges, and the state of Florida said that he could not have a lawyer despite the fact that it was guaranteed in the Constitution. He took this to court. He got it to the Florida Supreme Court. They said, no, it doesn't violate your rights. And then he took it all the way up to the Supreme Court, like the United States Supreme Court, and they said that, yes, his rights had been violated because it is guaranteed in the Constitution.
And the third landmark case pertaining to the U.S. judiciary that we found was the 1966 Miranda v. Arizona, which established the rights of suspects against self-incrimination. Ernesto Miranda was arrested in his house in 1963 on the charges of rape and murder, in that order. And after police interrogation and not being told his rights to an attorney and his right to remain silent, his Fifth Amendment rights, a lot of the lower courts found him guilty for his charges. However, he appealed to the Arizona appellate court asking that his rights were not read to him, and therefore it is a violation. He shouldn't be held self-incriminated. And so the question of that case was, do the Fifth Amendment's protection against self-incrimination extend to police interrogation of a suspect? And the conclusion that the Supreme Court found in 1966 was that the Fifth Amendment requires that law enforcement officials advise suspects of the right to remain silent and to obtain an attorney during interrogations while in police custody.
So the German judicial system today is based on a civil law system, which is a comprehensive list of statutes or codes. They have the inquisitorial system, which is when the judges are actively involved in investigating the facts of the case. Germany's source of law is the 1949 Basic Law of the Federal Republic of Germany. German law is mainly based on early Byzantine law, specifically Justinian Code, and to a lesser extent of the Napoleonic Code, aimed towards the rehabilitation and of the criminal and the protection of the general public.
There are many rights in Germany that are similar to those in the U.S. pertaining to a person's arrest and in court. The first is the law that prevents police from subjecting subjects to physical abuse, torture, drugs, deceit, hypnosis, the usual. And just as in the U.S., where a person has the right to a speedy and public trial, in Germany, a suspect has to be brought before a judge no later than the day following an arrest. And during this first appearance, a judge is required to issue a warrant of arrest specifying the reasons. Otherwise, they have to release the suspect. While detained, a person selected by the detainee must be told of the detention any day after the arrest. And, of course, they also have the right of free access to legal counsel, just as in the U.S., except in cases involving terrorism. In Germany, they also have the right to public criminal trials and the same rights of due process as in the U.S.
So, right, the Germans have their own kind of court system set up, naturally. This federal court is ordinary and specialized. They have a primary legislation concerning court organization is the Courts Constitutional Act, which is pronounced, or GVG for short. There are 4 ordinary court levels: local court, regional court, higher regional court, and the Federal Court of Justice. Federal courts are largely specialized, and criminal cases, first 3 courts can have jurisdiction depending on each case. Civil cases, either the local court or the regional court has jurisdiction. Specialized courts include, the labor courts, local, state, or federal. Social courts, again, local, state, or federal, as well as financial courts, which is state and federal, and administrative. The Supreme Court is a federal constitutional court. It regulates consequences of crimes against humanity, genocide, and war crimes, gives German courts universal jurisdiction in some circumstances, however, and may only be called if a constitutional matter within a case is in question, much like the U.S. Supreme Court.
Attached to the judiciary is the prosecution, but it is also kept separate from the courts. It is concerned with the criminal proceedings, like reviewing police investigations, handling criminal prosecutions, that sort of thing. They are the ones who establish the facts where a person is suspected of a crime, and they are also the ones who decide whether the proceedings will continue on into an actual trial or if they will stop the proceedings. In court proceedings, they are the prosecuting counsels.
So in the United States judicial system today, some of the basics, each state has their own judicial system, as does the federal government, and they are separate. Each court has their own jurisdiction, and the jurisdiction is geographically based as well as based off of the subject matter. All judicial systems also have their own appellate court systems, and all systems have their own Supreme Court, which is their highest court and their last resort. And they will hear a case before it will go to the U.S. Supreme Court, which is the absolute last resort for a case.
As you can see here, there are 3 different sections to the court system in the U.S. There is the federal courts, which start with the U.S. Federal District Court and then move on to the Federal Court of Appeals. There are the state courts, which start with local trial courts and then move on to appeals. And then there are the specialized courts, which include military appeals and the Court of Claims, for instance. And at the very top of the federal court system is the U.S. Supreme Court. So the federal court system was established under the U.S. Constitution, and it's divided into districts and circuits. They have limited jurisdiction, such as constitutional issues or interstate conflicts. The state court system, on the other hand, was established by the state where it's at. Most legal issues are resolved at state trial courts, which is the lowest tier in a state's court system. And state courts, unlike federal court system, the federal courts have broad jurisdiction. Appeal courts, which can be seen at both the federal and state level, review decisions made by the lower district courts or the lower local trial courts.
Right, so lawyers in America have an interesting approach as to how they become a lawyer. First off, in order to start the whole long road of getting to become a lawyer in America, first you have to get your high school diploma or GED, and then once you have accomplished that, with that fundamental, you then go on to post-secondary education, whether that is to a university, college. It has to have a 4-year degree, though, in order to apply for law school. While in an undergraduate program, a person must take the law school admissions test, or LSAT for short. Once they have their undergraduate degree, and should they have a high LSAT score, you are then able to apply for law school. Once you are admitted into an institution, they must go through 3 years or 6 semesters worth of education. And finally, to be allowed to practice law legally and openly after completing these 3 years of rigorous academics, they must pass the bar examination. And then should they pass all these things and do well in their studies following this process, the person is now a lawyer.
So in America, there's really 2 main levels of laws that we have. We have the laws that are at the state level, and then we have laws that are at the federal level. At the federal level, these laws are considered the supreme law of the land, which means like states can't make laws that disagree with it or go against it. And so technically the marijuana laws in Colorado would be an example of this not being enforced right now. And then state laws can be additionally set up by states to add on to laws by the federal government, but they cannot contradict or repeal laws that the federal government has in place. This is also why some states do have differing laws in terms of like drinking age, drug use, punishments for certain crimes, speed limits, those sort of things. And the federal government cannot directly tell the states what laws they can make, but they can influence them and persuade them into passing laws with the power of the purse.
So the judges in the U.S. court system are either appointed or elected. Justices of the U.S. Supreme Court, the federal court system, the appellate court system, and the district courts are appointed by the president with the approval of Congress. At the state level, judges may be appointed by the governor, elected by citizens, or elected by ballot by the 2 houses of the state legislature. Federal judges have lifelong tenure, and state judges usually hold office for a specified number of years. If a judge appointed at the state level is appointed by the governor, then the governor will determine the number of years that the judge will serve. Some states have fixed terms for judges. At the state level, all jurisdictions have mandatory retirement age, while at the federal level, they do not. For example, New Hampshire, a state judge must retire at the age of 70. In all jurisdictions, judges can only hold office if they have good behavior and behave ethically. If that statute is violated, the judges may face being removed from the...
All right, now that we've heard the history of both the U.S. judicial system and the German judicial system, and also how both of them are run today, we can kind of get into the specifics of how they're different. The U.S. is a common law system, while Germany is a civil law system. In common law, case law is the most important. It's published judicial opinions and precedents is what judges go off of. In this system, the role of the judge is more of a referee. They have greater flexibility to fashion an appropriate remedy at the end of the case than those in a civil law system. The role of lawyers is also different in a common law system. They make presentations to the judge, sometimes to the jury, and examine witnesses themselves. They're very much more involved in the court process. Much of the time, they have to stand before the court and attempt to persuade others on points of law and fact. And they maintain a very active role in legal proceedings, unlike lawyers in the civil law system. Also in the common law, only fully licensed lawyers can prepare legal documents. On the other hand, in the civil law, codified statutes are the most important. In Germany, these would be the basic law. The role of the judge in this system is investigator more than referee. They bring charges, establish facts through witnesses, examination, and they apply remedies found in legal codes. So in this system, there would be no jury. The role of the lawyers in this system is also very different. They're less active in actual court proceedings, and they represent the interests of their clients in civil proceedings. They advise clients on points of law, and they prepare legal pleadings for filing with the court, which is the same as common law. But the importance of oral argument, as seen in the common law, is very diminished, along with in-court presentations and actual active lawyering. In this system, non-litigation legal tasks may be left to quasi-legal professionals, such as will preparation and contract drafting.
So with all this information being thrown at you, you're probably wondering all these differences between German and American law. However, the one major difference between the two is the use of juries, or lack thereof, for the German government. U.S. defendants have the right to trial by jury. However, German defendants have a judge or a panel of judges that decide their case and their convictions. Juries in the U.S. only serve on one trial, while judges in Germany serve for several trials, as it is their profession. In the United States, the judge concedes to whatever the jury decides when it is a jury trial, while in Germany, the judge and others consult together on what the decision should be. In Germany, once a prosecutor has the job, they stay in that job for life, while in the U.S., attorneys are always changing, whether it be a defender or prosecutor. And the punishment in the United States is usually harsher than it is in Germany. Germany does not use a bail system. The defendants only stay in jail until their trial, and if they are considered a flight risk or a danger to the community, otherwise they are released without bail. Class action suits are not allowed in Germany, and lawyers there cannot work on contingency fees.
So one of the big differences between the U.S. Constitution and the German Basic Law is that the U.S. Constitution has been amended only 27 times in its 222 years of existence, the most recent being May 5th of 1992. The German Basic Law has been amended 55 times in its only 61 years of existence. Another difference is that the U.S. Constitution has the Bill of Rights, and the Second Amendment, the right to bear arms, is non-existent in German Basic Law. So they do not have that same right that we do, but they have 19 articles versus our 10 that are in regards to individual rights. And then between both of them, there are some similarities, one being that federalism, which sort of gives both certain powers to the federal government or splits powers between the federal government and the state government. The government is separated into three branches: the legislative, executive, and judicial, and both are popular vote. The similarity is that both are popular sovereignty or republicanism, which sort of means that both constitutions outline the principles of a republic.
The U.S. has an adversarial system, which is the prosecution proves defendant is guilty before a neutral judge or jury. They call witnesses before the judge and the jury. Judges can ask questions to clarify, but they cannot investigate. Truth is likely to be found when a judge or jury decide if the defendant is guilty beyond a reasonable doubt or not guilty. In Germany, they have the inquisitorial system, which is the judge in charge of inquiry. Judges control police investigation. There are written documents prepared using the evidence collected. Documents are presented to the court with different judges. The courts call the witnesses to investigate the accuracy of the document, and then the verdict is finally reached.